In this video, we would like to discuss one of the very important doctrine in law of contract, that is the doctrine of frustration. And doctrine of frustration as defined under para second of section 56 of Indian Contract Act, which deals with doctrine of frustration as a contract to do an act which, after the contract has been made, becomes impossible, or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful, and that is impossibility of performance. So, regarding that, we'll discuss the very leading case, that is Taylor versus Caldwell in 1863, and that is the very basis of modern doctrine of frustration. In that, it was established that where the performance of contract was made impossible by the destruction of a specified thing, the promisor might be excused. In this case, the defendant had agreed to give the plaintiff to use his music hall for the purpose of holding concerts. Before the days of the concert, the hall was destroyed by fire, and Taylor sued Caldwell for damages for breach of contract. It was held in the case that the contract is not so construed as a positive contract but is subject to an implied condition that the parties shall be excused in case before breach performance becomes impossible from the perishing of the thing without default of the contractor. So, this is the very opinion held by their lordship in the leading case, Taylor versus Caldwell in 1863, and the very supervening circumstances or events which create impossibility of performance, such as unlawful due to some events not under the control of the promisor. So, one is the destruction of the subject matter, which already we have discussed in the leading case, Taylor versus Caldwell. So, regarding that, we discuss one illustration. The Culture Department books a national dance festival at Sangeet Natak Academy, but before the performance of the dance festival, the very building was collapsed due to an earthquake. And our second is, after destruction of the subject matter, the second is change of law. And where there is a change of law, then also it would be considered as a supervening impossibility. So, when a particular promisor order for supply of a particular wood from forest, but now the law prohibits it. So, as an illustration, we could discuss a sawmill ordered for supplying teak wood to the forest department, but in between the central government enacted the Forest Conservation Act 1980, and which prohibits the very supply of such woods from forest. So this is change of law, and it is a kind of supervening circumstance or event which makes the very performance of the contract impossible. And our next one is non-occurrence of the event. So in that case, we could like to discuss an English leading case, that is Krell versus Henry. So here the very petitioner booked a room and ran to witness the coronation of King Edward VII. But the very coronation of the king was cancelled. So there is the very supervening circumstance or event, that is non-occurrence of the event, which made it a supervening impossibility in performance of the event. And in that connection, we could like to discuss one illustration. International Society of Krishna Consciousness booked a residential building at Grand Road, Puri, to witnessing the car festival. But the very car festival was cancelled by the Puri temple administration due to COVID pandemic. And now we'll discuss the next supervening impossibility, that is personal incapacity or death. So, a order for painting. So, in that connection, we could discuss one illustration. Peter ordered for a painting to William, who is a painter, but William met an accident in between, and both of his hands were operated, and now he is incapable for painting. So here the very reason accident makes the promisor incapable to do the painting, and same way we'll discuss how a teaching of and a personal skill or qualification becomes the subject matter, creating personal incapacity or death. And in that connection, a coaching center reached an agreement with Professor Siddhant to teach zoology, but in between Siddhant died due to an accident. So these are the personal incapacity or death which render the very performance of the contract. So it is another kind of supervening impossibility. And now we'll go to the fifth one, that is outbreak of war. So in that connection, we could discuss that in case of outbreak of war, alien enemies became friend, or but due to war they made impossible to perform the contract. So for example, we could take the example of India versus Pakistan. A merchant from Mumbai reached an agreement to supply edible oil to a merchant of Karachi. Just then, war breaks out between India and Pakistan. So now the very contract could not be performed, and it is due to impossibility of performance due to supervening circumstances or events. So all these conditions created out of supervening circumstances or events which made impossibility of performing the contract by the promisor. So this is better explained under the very doctrine of frustration, and regarding that we would discuss certain leading cases like the Creekwood Property and Investment Trust versus Lytton's Investment Trust 1945, then Satyabrata Ghosh versus Manga Niram 1945 by the Supreme Court, then Rahim Baksh versus Muhammad Shafi 1971 by the Allahabad High Court, and Punjab Sons Private Limited versus Union of India and others in 1986. And the last leading case relating to supervening impossibility of performance which falls under the doctrine of frustration is C.T. Xavier versus P.V. Joseph in 1995, Kerala. So in our upcoming video, we will discuss all these leading cases in detail relating to doctrine of frustration.